Hello. Ken Paxson recently announced that his office captured 6 suspects, 5 accused of online solicitation of a minor, and 1 for prostitution. Mr. Paxson had this to say about his team.
Their grotesque targeting of children is a nationwide issue, and this serves as a reminder that our communities must remain vigilant to protect the most vulnerable from exploitation, said Attorney General Paxson.
Paxson's office says to date they have made 264 arrests and obtained 194 convictions having to do with online solicitation of minors.
From the Attorney General's office? Any guess? 4,200 people. And over 100 officers.
Mr. Paxson is seen in this video explaining that the majority of his staff and time are spent collecting child support because of the millions in federal incentives by way of Title 4D funds. Pops will be reporting more on this later. This week's failed 3rd grade math recipient is Craig Hastin, with honorable mentions to Steve Bresden and Bill Morris. On April 24, 2019, there was a juvenile justice review in Austin, Texas for 2 equal shared parenting bills. The Family Law Foundation provided some interesting math, stating under 153.317 of the Family Code that it's almost exactly 50%.
Mr. Chairman, my name is Steve Bresnan. I'm here for House Bill 1807 and against 2157 and 3414 on behalf of the Texas Family Law Foundation. First, I want to thank Reverend Sanford and Representative Middleton. We've had some very thoughtful discussions about these issues this session and in previous sessions. And I also think it's fair to demonstrate that we fully respect the degree of emotion and heartfelt sincerity from the witnesses that have preceded me. For every one of those individual situations, there's a story, and if we could get into them, we could probably see what went wrong. Bad facts, bad judges, bad lawyers, any number of things. For every one of the situations that people have testified that they're unhappy with the result, there's somebody on the other side of that equation who was happy or satisfied with it. And so those people don't tend to come out to these hearings. I want to just clear a couple of things up. I'm handing you a schedule. If a person elects all of the rights that they have, all the options that they have under 153.317 of the Family Code, this is what they would get. In 1 year, 2018 is demonstrated, 2019 is demonstrated. The yellow pieces are overnights. The green pieces are the times when the kid woke up at that non-custodial parent's home, and they got them, presumably, they fed them, got them clothed, got their school books, got them off to school. You can look at the bottom on each one, 138 overnights in 2019, 43 of the other days, comes out to almost exactly 50%. In 1807, if you'll look, we've reorganized the statute to make it absolutely clear that people have a right to increase their time by exercising the options that are in the law.
Okay, Mr. President, appreciate for being here. Question for Mr. Bresnan. Representative Callahan.
I just want to say what you just kind of rephrase what you said. You said that in all of these cases that we could probably look at them and see what happened, and that there would be bad judges and bad lawyers in some of them as to why the outcomes came about. And I think that that's a really good point, bad judges and bad lawyers, but that's why we need good laws in order to protect parents and children in the state of Texas.
Although obvious that the representatives didn't buy their nonsense, the bills mysteriously did not, as with the previous 12 years worth of bills, make it out of committee. The Family Law Group posted this message on their website. The POP team is going to be investigating on why, although there have been equal shared parenting bills submitted to the floor each session over the last 12 years, they inexplicably get killed for Clinton-esque reasons, but bills like the lemonade stand bill and the already possessed gun rights bill are getting passed. Many people, including the Office of the Attorney General, are confused about how actual child support is calculated. During a child support review, this representative tried to mislead the person on how child support was calculated.
Okay, so section 154.062 talks about net resources. You don't go by that.
We don't go by your net resources on your paycheck because we can't take it.
In In the state of Texas, most judges follow this formula to calculate child support. If, for example, the net resources, not gross resources, is $3,000, the child support will be $600 for one child and $750 for two children, before health care and providing for the child in his own home. The cost for health care and dental will be added to the amount, making the percentage much higher. The POP team will be conducting an investigation on child support calculations in an upcoming broadcast. Many parents are shocked to learn that the Office of the Attorney General is indoctrinating their children with the child support game with their Parenting and Paternity Awareness Program, or PAPA for short. This program teaches boys that their job as father is to pay money to the state for their kids. For the girls, the program teaches them that their job is to put their baby daddy on child support so that they can get 20% of their income. They also learn that if they have babies by different fathers, they can get 20% from each of them. The next story has to do with modern day's debtors' prisons. You could be next. As any history buff knows, debtors' prisons were banned under federal law in 1833 and affirmed by the Supreme Court under the 14th Amendment's Equal Protection Clause. But why is it still happening today? Lawyer Alec, and I'm not even going to try to say the last name, said in the 70s and 80s, we started to imprison more and more people for lesser crimes. In the process, we were lowering our standards for what constituted an offense deserving of imprisonment. And more broadly, we were losing our sense of how truly serious it is to incarcerate. If we can imprison for possession of marijuana, why can't we imprison for not paying back a loan? Karen Martin, professor at John Jay College, coined the term criminal justice debt. Next came the fiscal crisis of the 2000s, during which many states were contending with budget deficits and looking for ways to save. Many judges felt pressured to make their courts financially self-sufficient by using the threat of jail time, establishing those statutes to squeeze cash out of small-time debtors. To help feed the $60 billion a year industry, Texas adopted the contempt of court, aka go to jail, to ensure it maximizes Title 4D funds. For all those who applaud the courts for putting people in jail for being unable to, not unwilling, to pay this debt, tomorrow it may be your student loan, your car loan, or even a traffic ticket. Comment below with your thoughts. And finally, this week's toasty moment goes to Michael Burton as he was called out for his nonsensical rant.
I've had a lot of parents come to me and feel that they leave the court and they don't know why they got the percentage that they got. This bill says that the judge must put it in writing, and I think that's very important. So why do you think that that's not important?
Currently, by statute and case law, they are required to put those decisions in writing. It first started that they were to put it on the record at least. Now it's been perfected, again, evolution, as I say with law, that they are to. So it's disappointing to hear that you have come across some litigants that have had that experience because they shouldn't have that experience. Again, and I don't mean to minimize this, when you walk down the street, you've got good dentists and good orthodontists. We were shopping around for my kids' teeth. Sometimes, you have somebody that does a better job than the other. We do a check and balance system of appellate work to be able to correct those issues. But if something like that happened, as you explained, and that case was appealed, that would be a problem for that trial judge. In that case, they should definitely know. And that was part of what we put together in our statute that came out in 2011, 2012, and perfected since, that litigants should know why a decision was made and why there might be an extra night here or an extra dinner here or what have you. Thank you for that question.
Well, I just think you said about good and bad in every profession, but I think this will make every judge pay attention more to what's happening in court, and the outcome will be a lot better. So I appreciate your testimony because we want to hear pros and cons, but obviously we're all here today for the betterment of the child. I mean, that's what our all concerns are. Exactly. So thank you. Toasty!
Sorry, I can't let this go. When I watched Mark Ludwig give his testimony and watching him in the background, it reminded me of this scene from A Christmas Story.
Has anyone seen Flick?
Flick? Flick who?
He was at recess, wasn't he? Ralphie, do you know where Flick is?
What a Mr. Magoo. All right. Well, thank you for listening. Please hit the like and subscribe buttons and to be updated on new programs and other broadcasts that I'm working on. Please comment below with ideas for future shows. Thank you.